I'm very excited to announce a 10-part series with Yasmine Adamy, probate attorney and estate planning. Today, we're going to be discussing how do you transfer property when a parent dies. All right, today we are with my favorite probate attorney, Yasmine Adamy. Yas, say hey.
Hey, everybody out in the Facebook and YouTube world.
Absolutely. Today we're going to talk a little bit, some questions about probate, some questions I've been asked. I'm sure Yaz has been asked these, and I guess we'll just go ahead and kick it off. So first question I have here is how to transfer property after the death of a parent. So, I'm a guy. The unfortunate happened and one of my parents died and they had some property. What do I do?
So the first thing that, and this is something that we deal with pretty much every day as a probate law firm and also an estate planning law firm, this is a very common situation, whether it's an expected loss or it's unexpected. There's property that has to be dealt with. And when it comes to how to transfer that property after your parent dies or after your loved one dies, there's a few different considerations. So if someone were to come to my office, I'd say, hey, listen, let's first see what your mom or what your dad owned. What is in their name? What type of property is it? Is it a bank account? Is it real property? Is it a vehicle? And then the next question is, did they have a last will and testament?
Sure.
And if they have a will, it's important for us to see the will to make sure it's valid. But even if they have a will, probate may be required. So the first thing I want to say right off the bat is a last will and testament does not keep probate from happening. A last will and testament is only valid if it goes through probate. Probate is a court process, and it can be fully avoided through estate planning. So then let's go back to the original question. How is property transferred when somebody dies?
Right.
Well, if it's a bank account and it's a joint bank account, meaning let's say there's, you have a joint bank account with your mom and she dies. By operation of law, that bank account will go to you, account holder. But if there's nobody on that bank account, then we have to go to probate. And that is how that bank account will be transferred. If there's a will and the will is a valid will, it'll go to whomever the will says it should go to. If there is no will, there is something called the laws of intestacy, which is under the probate code, which is it's a Florida statute, and that will state who gets what. And it's a default rule. So people use, a will, even though it doesn't avoid probate, it can certainly bypass the default rules of who Florida thinks you would want it, to get your stuff. So when it comes to real property, let's say real property is in your parents' name and they pass away. Got to go to probate. Off to probate we go. It can be, that can be avoided through estate planning, which isn't part of what we're talking about right now. Right. But just probate is usually required. It's a court process, required whether or not you have a will, and it can be avoided through estate planning.
So if I have, even if I have a will, in order for me to transfer my inheritance or property or maybe even find out if I have any rights to it, does it have to go through probate? How does that work?
So one thing that comes up a lot is this. Maybe a month ago, we had two girls who were out of state and their grandpa died. And they were, they're his heirs, but they had no idea what he had and what they may be entitled to receive. They thought that he may have an account at ViStar, but they didn't really know. Once somebody passes away, and really, even if they're alive, ViStar isn't just going to volunteer this information. You're going to need to show the bank, in order to find out whether or not an account even exists, some type of a court appointment, which is through probate, if the person is no longer alive. If the person is alive and you have a power of attorney document, that would work, but a power of attorney is no longer valid when someone dies. So with these, so with these two girls, we had to open up a formal administration in order for them to do the research to see if their grandfather had anything. And they did. They found out he had a few different accounts, but he had somebody listed as a pay on death beneficiary who was like their cousin. So that wasn't, they could not collect that. A pay on death beneficiary, when it comes to a bank account, that means that when the person dies, it goes to whomever they've designated as their beneficiary. So, but without the court paperwork, which it's called letters of administration, the bank wouldn't talk to the granddaughters. So we actually had to get the girls appointed as the personal representatives of their grandfather's estate. So then they could show these letters of administration to the bank and the life insurance company, anywhere where they thought that he may have assets. What I always tell people is, if you're not sure if your loved one has an asset and you think you're probably under the laws of intestacy or under a will, that you are an heir, like, and there's a prior, like there's sort of like a different classes of heirs of who has priority over who. Right. To make sure that you don't, make sure that you take a look at what is coming in the mail, because that is usually a very good indicator of possible assets. So okay. Like if your loved one has bank accounts, they're probably going to get banking statements. If that makes it a bit easier to know what kind of a court proceeding we need to do. When there is no way to really tell what the assets are, and the banking institutions, of course, won't talk to you, then we have to do a formal administration, which is the most full-blown type of a probate case. It's expensive, it's time-consuming, but it is what is required in order to have the authority to find out information about possible assets.
So it sounds like that's why estate planning is important. It sounds like there's a whole lot of red tape that can happen if you don't have your ducks in a row there. So
it's complicated.
All right. So the first step to transfer property is, so does the court try to figure out what everything, what all they own, or is that the estate planning attorney's responsibility?
The probate lawyer and the presumptive heir. So,
okay.
Let's say, your parent passes away, and it's a situation where you're close with your parent and you kind of have, you have a good idea of what some of the assets are. I mean, the first thing I would ask if you came to my office for a, discovery session or whatnot is, okay, so tell me a little bit about your family. Was your mom or were they married? Who did they have as children? Did any of your siblings pass away? If so, did they leave any children? Did your parent have a will? So those are all questions that are, the answer determines the type of probate path we will need to take.
Okay.
If, a lot of times folks will call and we'll set up a meeting, and it turns out that they're not next in line as an heir. They thought they might be, but actually there's someone who is under the laws of intestacy who has more of a right than they do. And I'll just let them know, hey, listen, you're not actually not, you're not you're not going to receive an inheritance because of this. And it really depends on who the family tree and when people passed away, because it shows on how things will vest. If there's a will, the question would be, all right, do you know if your parent did a will after this one, later in date? If not, then we go to probate the will, and whatever the will says, as long as it's a valid will, is how those assets will be distributed. Now, it's important to remember, even if a will says that a bank account goes to one person, but the actual bank account has someone else listed as a beneficiary, the actual beneficiary designation trumps the will. So I've had folks come here and they'll say, hey, listen, here's my mom's will. I get her SunTrust bank account. And then lo and behold, we find out, no, your sister was the beneficiary.
That's
Too
not a
bad.
fun
I mean,
conversation.
it's the way it works. And it happens a
Yeah.
lot. But yeah, so to transfer property after death of a parent or a loved one, it truly depends on the type of asset, whether there was any estate planning done to avoid probate, if there's a will, and if there isn't a will, who, family tree information.
Okay.
And that's how we do it. If we can avoid probate, we do. Um, can't always avoid probate though. That's the thing. I mean, if something like, let's say there's a bank account or a real property and nobody is listed as a beneficiary or a joint account holder,
Yeah.
we're going to probate land.
Well, it sounds
So
like
then we,
real property is almost always in probate land, unless they've talked to somebody like you who's set it up to where you're setting it up on purpose to avoid the whole probate situation. Um,
exactly.
okay. So you're almost always going to how often would you say that people actually do the estate planning that really needs to be done? I mean, is that pretty prevalent or is that pretty rare?
85% of people do not have an estate plan.
Yeah.
Um, and those that do probably have not addressed the homestead, the real property. They'll have a will, not understanding. Most people who come here don't understand, and it's because it's not logical. They don't understand that in order for their will to do anything, it has to go through probate. They'll say, but here's the will and it says that I get the real property. Yeah, but we need to go to probate. Why? My mom did a will. Yeah, but the court needs to say that the will is actually valid and it's to make sure it isn't fraudulent. Imagine if every will was honored and it, didn't have to go through probate. We'd have a lot of civil litigation of fake wills with fake beneficiaries.
Yeah.
So to probate is to prove. Like the word probate truly means to prove the will.
Okay.
And then once the court looks over the paperwork we submit, and if everything looks good, the judge will sign something called an order, and it's that order that actually transfers the property.
Okay.
So if it's a bank account, my client would bring the court order to the bank, and that's how that would transfer that bank account to whomever is listed as the heir on the order. Real property, if it's homestead, there's an order determining homestead, and that says who gets the homestead. If it's non-homestead, meaning like a rental property, it's an order of summary administration or an order of administration that states who gets it. But in order to get the order, in order to get the order from the judge, it's a petition that is submitted asking, telling the judge, hey, listen, this is what's going on. This is what we're asking. And he looks it all over. And if he thinks it looks fine and we've done all of the requirements under law, he'll sign an order. And that is how property and how assets are transferred if probate's required.
Okay, so it sounds like a lot of time it's probate, and then the first step is kind of petition the court, and then telling them everything that's going on, and then you get an order from the judge, and then the property's transferred. Is that kind of sum it up?
Pretty much. Mm-hmm.
Yeah. Okay. How long does that process take?
So it depends. It always depends.
Doesn't it?
If the individual has been, if they've been deceased for longer than 2 years, we can do a summary administration as long as we know what the assets are. And a summary administration is pretty quick. If they've been gone for longer than 2 years, we do not need to notice creditors. We don't need to do a publication, which saves a lot of time, saves a lot of money. If somebody, and that usually depending on what jurisdiction you're in, summary administration can be done as quickly as 2 weeks. It used to be a lot easier when we could go to court, but right now we cannot actually go to court. Before we could go to something called ex parte, where you could have the judge sign the order right then and there, drive down to court, go to ex parte, judge signs the order, summary administration done like in 2 weeks.
Nice.
It can still get done pretty quick, but it depends on what is going on with the court, because how it works is we e-file the petition. Then once we get a case number, we'll email in Duval, we email the order to the judge's judicial assistant. And if she's really busy, it might take her a few weeks to really kind of see what that is. And then there's a bit of a time lag. So summary administration can be very quick. If somebody has not been gone for longer than 2 years, and the value is over 75,000, not including the homestead, because you don't include that value when it comes to figuring that number out, we need to do a formal administration. That takes quite a bit longer because we have to publish a notice to creditors. And that notice to creditors, it has to be 90 days from the first date of publication before you can close out a formal administration. Okay. Creditors have 90 days from the date that you first publish. So with formal administrations, the goal is to open up the case as quickly as possible and to publish to get that 90-day period running. Okay. And then if creditors come forward, they have to be dealt with. So formal administration can take quite a lot longer. If there are a lot of assets, it can take months.
Best case scenario, like 2 weeks. Worst case scenario, like 6 months, a year.
They want us to close formal administrations out within a year. Okay. But there are some formal administrations that can't be closed out in a year because there's too many issues. Yeah. So yeah, really, I mean, so best case scenario for a summary administration is like 2 weeks to like a month, I would say. Best case scenario for formal administration is at least 90 days to, I don't know, a quick formal administration could be done in about 6 months. Okay. But it has to at least stay open for those 90 days.
All right. So I'll wrap this one up. I'm just going to wrap it up with a summary real quick. So real property, most of the time, like a strong percentage of the time, we've got to do a probate. The probate, no matter how long it takes, whether it's 2 weeks or 6 months, once that starts with what is the word terminology? The petition. Yes. So it starts with a petition. It ends with the judge finalizing it with an order. After that, does a deed have to be recorded or is that done?
So the order actually serves as the deed. So
really?
The order, yep. So like an order when it comes to homestead, that actually is recorded and it's just the court records it. Nice. And it shows up in the official records. Okay. And that is what serves as the deed. So like right now I've got it's going to be a summary proceeding, and it involves homestead. And eventually what will happen is the judge will sign an order and that will show up in the official records. And it will show that, the heirs, the names of the heirs who actually own the property because of the order.
Gotcha.
Yeah. So an order is like a deed.
Okay. You got probate, and then you got petition, you got judge's order, which serves as the deed, and then you're done. Property's in your name now.
When you're done, yep. And then property's in your name. You can do whatever you want with it.
Nice.
If you've got siblings or other heirs, make sure everybody agrees.
Well, Yaz, I want to thank you so much for answering that question for all the viewers out there.